Deon Watson against the King.
Before we begin, on behalf of the Board of the Privy Council, I'd like to express our sympathy to the people of Jamaica who are facing the onslaught of Hurricane Melissa, and in particular to the relatives of those who have already lost their lives. We also are very concerned for the people in the Dominican Republic, where lives have also been lost, as they have been in Haiti. The Dominican Republic Supreme Court hosted me as a visitor earlier this year, so I've got to know people there. So our thoughts, as I say, are with the people of the Dominican Republic and Haiti, and especially Jamaica as one of the jurisdictions for which we act as the highest court. Mr. Lewis.
My Lord, yes. My Lord, my Lady, I appear on behalf of the appellant in this matter, together with my learned friend, Mr. Christopher Jenkins. My learned friend, Mr. Rowan Pennington Benton, appears for the respondent. Can I briefly outline the proposed structure of my submissions? The proposal is that I have 2 hours this morning, and my learned friend then responds, with an opportunity then for me to come back by way of reply this afternoon. My plan for the morning is to give at the outset a brief overview and just a very brief recap of the procedural history of this matter, then to look at the relevant legal test for appeals of this nature in some depth. Next.
If it helps you, I can tell you we have all read the papers, so we do know the procedural background.
Indeed. Well, I'll skip over that then, my Lord. Sometimes useful for the benefit of those who haven't the assistance of the papers but may be watching, but I easily pass over that. After looking at the legal test, going to move to identify some key aspects of the case from the trial transcript, and then make submissions on each of the 4 issues that are identified in the statement of facts and issues. And you have that in your key documents behind tab 2. It's page 1404 of the electronic bundle. I'll address each in turn, though plainly they are interrelated to a considerable extent, and also worth perhaps making the point at the outset that on 3 of the 4 issues, all we on behalf of the appellant are seeking to do is persuade the court that the decision of the Court of Appeal of the Bahamas should be sustained on those 3 issues. That's the first 3 of the 4.
Does the appeal not raise a very short point? If the verdicts are inconsistent, then you succeed. If they're not inconsistent, you fail.
My Lord, yes. Yes.
So inconsistency is a critical issue.
Indeed, and what that means, I suppose, may be the subject of dispute, certainly. We each have a different position on whether the verdicts are inconsistent. But
we don't necessarily succeed, do you, if they're inconsistent?
Oh, it was subject to the proviso.
Yes.
Well, it's subject to safety.
Yes, it's not the proviso, it's the application of the test, which is whether the conviction is unsafe. The Court of Appeal held that even if the
yes,
blood, etc.
Yes, it's not quite that straightforward.
No, but inconsistent, you have to get...
Indeed, certainly I need to meet the target of inconsistency, but it depends very much on what considers inconsistency to mean. So this is an appeal, as the board will of course know, from a 2016 conviction before the Supreme Court of the Bahamas on 3 counts of possession of a firearm with intent to endanger life and 1 count of damage, which Mr. Watson, the appellant, was sentenced to a total of 15 years imprisonment. In the same proceedings, he was found not guilty on 2 counts of armed robbery, and the verdicts are neatly set out in a table at page 3 of the statement of facts and issues. And you have there...
The armed robbery counts were in relation to particular tenants, weren't they?
Well, they were, my lady,
not
yes.
Not to the bank as a whole.
No, but that's simply a form of pleading, because one robs a person rather than an institution.
But it may be of significance when we come to inconsistency.
My lady, it may well. But there's nothing unconventional in my submission in pleading a bank robbery with reference to the individual who handed over the money.
The respondents say it's perfectly logical that the jury worked through it and found out what each accused did and returned verdicts on that basis.
My Lord,
that's a logical explanation for the jury's verdict.
He does, but it would require them, if that is what they did, to have departed from the clear directions on joint enterprise they were given, and to have effectively disregarded what the Crown at first instance said was a confession by the appellant to involvement in a joint enterprise armed robbery.
Well, it's up to them what evidence they accept or don't accept, isn't it?
Well,
That's what the jury is there for. Well, they're not bound to accept joint enterprise just because the Crown present the case on that basis.
No, my Lord, but one needs to consider whether, in the circumstances of the particular case, on the facts of the case, such a decision is a reasonable.
But you're getting it the wrong way round. The jury decide what the facts are.
Well, my Lord, can I take the board then straight away to the legal test and where it's formulated? Because in my submission, a close examination of the facts of Durante, which is the case in which the formulation of Mr. Justice Devlin, as he then was formally adopted by the Court of Appeal, and those facts bear close examination. There are a few key features of the case of Durante that I'd ask the board to bear in mind. So you'll find that in the electronic bundle starting at page 1511. It's the case that Crown and Durante 1972, Weekly Law Report 1612. And you have there the judgment delivered by Lord Justice Edmund Davis, given the judgment of the court. And at page 1516 in the bundle, the formulation, the relevant formulation is there identified just below letter B. Lord Justice Davis identifies the formulation which first appears to have been used by Mr. Justice Devlin in a case called Stone from 1954, which was unreported, subsequently quoted approvingly by Lord Parker, then Chief Justice in the Crown and Hunt, a 1968 case, and it's formally adopted and approved here in the test in regard to the approach the court should adopt in cases of inconsistent verdicts, or what are said to be inconsistent verdicts, is the following. When an appellant seeks to persuade this court, as his ground of appeal, that the jury had returned a repugnant or inconsistent verdict, the burden is plainly upon him. He must satisfy the court that the two verdicts cannot stand together, meaning thereby that no reasonable jury who had applied their mind properly to the facts in the case could have arrived at that conclusion. And once one assumes that they are an unreasonable jury, or they could not have reasonably come to the conclusion, then the convictions cannot stand. And make the point again, the burden is upon the defence to establish that. So reasonableness is very much at the heart of the test.
Well, also logical inconsistency. They cannot stand together.
Well, my Lord, I'll come in a little while to look at Fanning and just explore where we get to now in the authorities in relation to logical inconsistency.
But that's the test you say applies.
Indeed, the test formally approved by the court in Durante, and I say recently reapproved by Lord Thomas, then Chief Justice, in the case of Fanning, which cuts through a lot of the subsequent journey of the law and says go back to Durante, go back to the Devlin formulation. But I'd like to take a few moments to look at the facts of Durante, because that provides the context in which this formulation was formally approved. And I'll submit in due course that certain key features of that case are equally present in this appeal. So Mr. Durante, we see at page 1512 at the foot of the page, was facing trial on 3 charges: handling a stolen cheque, count 1, endeavouring to obtain money on a forged instrument, count 2, and attempting to obtain money by deception on count 3. And he was convicted on count 1, found not guilty on count 2, and the jury was discharged on the 3rd count, and no more said about that in the judgment. Both counts 1 and 2 related to the same instrument, the same stolen cheque, and the allegation was that Mr. Durante had presented this stolen cheque to a publican and requested that it be cashed in his favour. He'd been turned away initially because it wasn't signed, and then when he returned to the same pub with a badly signed cheque, signed in the wrong place, the publican called the police. You'll see towards the foot of page 1513, upon arrest, Mr. Durante admitted that the cheque was obviously stolen. He said he'd bought it earlier that day for £2. He admitted that he told the barman it was his wages when attempting to cash it. And when faced with the allegation that he was being arrested for uttering a stolen and forged cheque, he replied, "I'm guilty." Clear admissions on the face of it to counts 1 and 2 on the indictment that he faced. Now at trial, he departed from that account. He maintained effectively he'd had the cheque pressed upon him by a man named Ferguson, who he met in a pub. He accepted he had made it out himself and said that when he presented the cheque, he was too drunk to form the required intent. You see that at page 1514C, towards the foot of that paragraph. Fraud was an essential element of both counts, but he said he was too drunk at the material time to be able to form the necessary criminal intent which it required. That account was disputed both by the publican and the arresting officer, who said he didn't seem in too bad a state to us. So effectively, he admitted the actus reus of both offences, denied the mens rea of both, and there was a single issue at trial relating to the capacity to form the required intent. Of further note, towards the bottom of that page, 1514G, the court observed that the deputy chairman gave a most careful summing up, which is of such a tenor that when the jury returned their verdicts, he must have been greatly surprised. But the court noted, nevertheless, it is to be observed that when rightly telling the jury the two charges required separate consideration, he added, they do not necessarily stand or fall together.
Were you reading from them, Susan?
I'm sorry, this is page 1514 in the electronic bundle at paragraph G to H.
Thank you very much.
And the observation there by the deputy chairman delivering the summing up, the two charges do not necessarily stand or fall together. The Court of Appeal went on over the page to analyse the verdicts between paragraphs D and H on page 1514, noted prosecution counsel's surprise at the verdicts, and concluded, just below letter H, that the verdicts were remarkably inconsistent. And it was in that context that the formulation already described was approved as being the proper test. Now, the court then went on.
But you're not saying this is a context-specific test, you're accepting this is the test.
Indeed, it is the test.
So
Why
does it matter what the context was?
Because there were some key features in Durante which provided the context against which the test was formally approved that I suggest equally apply to the present appeal.
Okay.
I'm going to set out in a few moments what they are, but it's important in my submission to the board understand the factual context against which Lord Justice Edmund Davis was saying this should be the test. Because Mr. Durante received the benefit of that test. At page 1516, starts just above letter F.
Just before we go there, if we go back to 1514 at G, you referred us to what the deputy chairman said.
Yes.
And the court goes on, such observation is frequently made, and perhaps in most cases with accuracy, but its validity must depend on each particular case. And then he says, in the light of the facts of the present case, possibly the chief point for consideration is whether it was realistic to say that the counts of handling and attempted to obtain did not necessarily stand or fall together.
My lord, yes.
Yes. So you are having to meet that high standard that you would have to show that the matters of which Mr. Watson was convicted and the matters of which he was acquitted stand or fall together?
Yes, I need to show that they are verdicts which no jury properly applying its mind to the evidence could reasonably have reached. But it's worth noting, my Lord, that the word realistic, in fact unrealistic, is used by the Court of Appeal of the Bahamas in its judgment in this case. I'll come to that in due course, but in essence the Court of Appeal said, well, the jury may have concluded that he was the man firing the gun, but not that he was involved in any robbery, but that's unrealistic on the facts of this case. But I'll come to the precise form of words they use in due course.
Yes, but you were taking us to 1516.
I was, yes, and this is where the court disposes of the matter. So 1516, just above letter F, Lord Justice Edmund Davis asks himself, or the court asks rhetorically, and then answers it rather, has the defendant discharged that burden, so the burden on him to show the verdict cannot stand? We think he has. It may be that the irrationality of the jury is manifested by their acquittal on the second count, and that a finding of guilt upon the first count was an entirely rational one, being solidly based on the evidence. But we are here in the realm of conjecture. We are satisfied, the court continues, that no reasonable jury who had applied their minds properly to the facts of the case could have arrived at the two differing conclusions that this particular jury did. It may be, the court notes, that they were guided to some extent by and perhaps applied in a different way from that intended by the judge. His observation in the course of his summing up that the two charges did not necessarily stand or fall together. And the conclusion is, however that may be, and whatever the explanation, the jury arriving at such conflicting verdicts was satisfied that in the result, the conviction on count one cannot be regarded as either safe or satisfactory. That was back when satisfactory was part of the test on appeal as well. And finally, the court noted in passing that this was so despite what many would regard as the clear evidence of guilt upon the conviction, upon the count on which Mr. Durante was convicted, and his conviction was quashed. And so the five key features of that case, against which the formulation was formally approved by the court, I'd flag for the board's attention of these. First, the appellant in that case had admitted upon arrest the offence of which he was ultimately acquitted. Second, the issue on counts 1 and 2 was the same, the capacity to form intent. Third, in summing up, the jury were given the standard direction that the charges required separate consideration, with the additional gloss by way of observation, they did not necessarily stand or fall together. Fourth, the court refused to enter into what it described as the realm of conjecture to seek to explain the inconsistency. And fifth, the conviction was determined to be unsafe, despite the fact that there was considered to be what many would regard as clear evidence of guilt. And in my submission, I'll go on to hopefully make good this point as we go through the facts of the present case. All of those features apply to the appellant's case and to this appeal. Now, post-Durante, the law relating to inconsistent verdicts went on something of a journey, and that's neatly distilled in the judgment of Lord Thomas, Chief Justice, sitting with Lady Justice Hallett and Lord Justice Treacy in the case of Fanning, 2016. It's the next authority in the bundle, in fact, starting at page 1517. So if the board would turn to that, this is an appeal, you'll see from the start, in which a number of cases were listed together. There were originally 5 listed together. One was adjourned because it related to fresh evidence issues and fresh inquiries were directed. But at paragraph 1 of the judgment, which you find at page 1520, it's made clear that the appeals were heard together with the adjourned appeal, because each raised the issue as to the proper approach on an application for leave to appeal where it is contended that the verdicts of the jury were inconsistent. And so the clear intention of the court in bringing these appeals together was to provide clear guidance as to the proper approach to be adopted, and we say it did. So Lord Thomas, in the judgment from paragraph 13 onwards, which you find at page 1525 and onwards, examined what had happened in the 40 years or so since the test was formally approved in the case of Durante. He previously identified the Durante approach, but here he goes on, delivering the judgment of the court, to look at the development of a more complex approach. And we can skip through the stops on the journey, if you like, and go straight to the destination, because at the bottom of page 1528, paragraph 13, Roman 12, by letter G, the court notes that eventually the position arrived at was clearly summarised in the case of the Crown and Dillon, in a judgment delivered by Lord Justice Elias. And it's set out there. So how we got there doesn't matter so much. This is where the law appeared to be as at 2016.
There's a very helpful passage, if I may say so, from the judgment of High Court of Australia, quoted on 1524.
That's in paragraph 11.
Yes, yes. From D to G is, I think, worth reading.
Yes, well, I can read that into the record.
No.
But yes.
We can read it for ourselves. But,
yes.
The important points are, well, if there's a proper way by which the appellate court may reconcile the verdicts, allowing it to conclude that the jury performed their functions as required, that conclusion will generally be accepted.
Yes.
And we go on. View may be taken that the jury simply followed the judge's instruction to consider separately the case presented in respect of each count. Alternatively, the appellate court may conclude that the jury took a merciful view of the facts upon one count, a function which has always been open to and often exercised by juries.
My Lord, yes, on that latter point, that's then specifically contextualised in the judgment of Mackenzie, the High Court judgment there, with reference to a position which pertained to the early history of New South Wales and juries being reluctant to convict defendants of offences which would attract the death penalty and returning verdicts on lesser counts, thereby resulting in transportation. That's quite a specific context, my Lord, in my submission, in which that formulation is expressed, or that concept.
Well, he's referring to an English case of Hunt.
Yes, I mean, this is the law being declared by the High Court in 1996 under reference to an English case of 1968. This isn't to do with transportation in the 18th century.
Well, my Lord, that's the context. I take that point, but that's the context in which the position is then explained as a matter of principle by the High Court in Mackenzie. So
there's also an important passage at the top of the next page, 4 lines down, that sometimes juries apply in favour of an accused what might be described as their innate sense of fairness in place of the strict principles of law. Sometimes it appears to a jury that although a number of counts have been alleged and technically proved, justice is sufficiently met by convicting them of less than the full number. This may not be logically justifiable in the eyes of a judge. It would be idle to close our eyes to the fact that it's part and parcel of the system of administration of justice by juries. The last sentence is also important.
And indeed, the court in this case, in Fanning, approved that at paragraph 16. That is to say, Mackenzie.
yes, and I'll come to the discussion of the court, but yes, my lady is quite right. That is. Equally, the court has to avoid being drawn into, in my submission, the realm of conjecture as expressed in Durante, and trying to second guess what a jury may have done. And on the facts of this case, there's no particular reason why.
Let's look at what's said at point 12 in page 1528. I mean, this is where you say the law has got to.
Indeed.
You're saying it's correct.
No.
Yes,
My Lord, I'm saying it's not
let's go through those.
Yes, my Lord, this is where the law had got to, and that is disapproved by Lord Thomas. So I'll take...
It was disapproved, okay.
Disapproved, so I'll take the board through these. So in Dillon, there were five principles identified by Lord Justice Elias. The first is the test for determining whether conviction can stand is the statutory test whether the verdict is safe. Of course, entirely uncontroversial then and now. Point 2, where it is alleged that the verdict is unsafe because of inconsistent verdicts, a logical inconsistency between the verdicts is a necessary condition to a finding that the conviction is unsafe, but not a sufficient condition. Point 3, even where there's a logical inconsistency, a conviction may be safe if the court finds that there is an explanation for the inconsistency. It's only in the absence of any such explanation the court is entitled to conclude the jury must have been confused or adopted the wrong approach, that the conviction should be quashed. Point 4 over the page, the burden of establishing the verdict as unsafe lies upon the appellant. And point 5, each case turns on its own facts and no universal test can be formulated.
Okay.
And his lordship, in that case, this is still quoting from Dillon, went on to look at what a logical inconsistency may be. He goes back, his lordship goes back to Durant and the formulation of Lord Justice Edmund Davis as identifying the test as being whether the verdicts were such that no reasonable jury who had applied their minds properly to the facts in the case could have arrived at the two differing conclusions. In other words, there's no rational explanation to justify the jury's conclusion.
And he accepts the important point that it's, of course, the jury's function to find the facts, and therefore what one's really looking at is whether the verdict could be explained by a view of the facts that was open to the jury.
Indeed, which must, of course, be judged in light of the facts as presented before them, but also the legal directions which they were required in law to follow. At Roman 13 there, the court identified some further additions to the summary in Dillon, made in the case of Jackson. The explanation for inconsistency must be an explanation which falls within the parameters of the case as summed up by the judge. And then in the case of B, just below at letter E, two further riders are added. The second, the first is if the court identifies an explanation as to why logically inconsistent verdicts may have returned, it will act on that explanation to dismiss the appeal only where it is a satisfactory explanation which justifies the conclusion the verdict is safe. And the second rider is that there may be rare cases where, although there's no logical inconsistency, the particular facts and circumstances render the verdict unsafe. But that's a slightly different point, it seems. But then, so this was how the law stood as at the date of the hearing in Fanning in 2016. And the conclusion of the court, starting on page 1530 from paragraph 15, is to say, stop, there's too much here, go back to where we started, please. So paragraph 15 was identified that in that unreported case of Stone back in 1954, Mr. Justice Devlin set out a clear test in cases where inconsistency between verdicts is advanced as a ground of appeal, applied in Hunt and formally adopted in Durant. It's the determinative test for setting aside a conviction in such circumstances as unsafe. It's a test that is clear, Lord Thomas, and it can be applied by this court without any further elaboration. And the test, referring to the Durante test, also accords with and does not usurp the constitutional position of the jury. Lordship refers to judgments in Seagull, Martin and Mackenzie there. notes that the jury is the body which is entrusted under the Constitution to reach a verdict that must be based on evidence, even though on rare occasions it may not be, in the eyes of lawyers, flawlessly logical. And the merit of the test is said to be that it recognises that constitutional position while providing the necessary safeguard for a defendant. The court goes on in paragraphs 17 and 18 to disapprove of more elaborate formulations or glosses that have been placed on the test over the years. And paragraph 19 concludes that in our judgment the court should return to the clear law set out in Mr. Justice Devlin's test, formally adopted in Durante, and apply it rather than the reformulation as now summarised in the case of Dillon, as qualified in Dobson and B.
You'll note paragraph 22 as well. But it'd be inappropriate to look at factual case, circumstances of different cases.
Indeed, the test should simply be applied without elaboration to each case without comparison to other cases.
Yes.
The heading at the top of paragraph 20 there on page 1531, cases are fact specific. Of course they are, but all the more so in a case where inconsistent verdicts is alleged, and only the facts and the law as presented to the jury in that case is really the stuff of consideration. But can I just finish on paragraph 19 to note that the court, in concluding its conclusion, as it were, says, in any event, as Professor Sir John Smith had previously pointed out, it's difficult to see how a legitimate chain of reasoning can justify a logical inconsistency. And that really chimes with the injunction against entering into the realm of conjecture that you find in Durante. If on the face of it, the verdicts are inconsistent, that in itself effectively is a mark of an unreasonable verdict. So it follows that concepts such as a legitimate chain of reasoning and the like are not the target. And the test goes back to that expressed in Durante. And one way of considering it or analysing what the court was trying to do in Fanning is drawing a distinction between the requirement that an appellant demonstrates the fact that the verdicts were unreasonable and a requirement which seemed to have started to emerge in the case law that he demonstrate how those unreasonable verdicts may have been reached.
I'm entirely certain that the test is unreasonableness.
Well, just going back, my Lord, it's expressed, I suppose, in a couple of ways. Page 15, 16 in the bundle is the Durante expression of the formulation. The appellant must satisfy the court, we say at D, that the two verdicts cannot stand together, meaning thereby that no reasonable jury who had applied their mind properly to the facts in the case could have arrived at the conclusion. So that really is the core of the formulation. No reasonable jury who had applied their mind properly.
That's a perversity test.
It's the word, my lady. I don't want to add gloss to the words on the page. We've been enjoined not to, but that will be a fair use of language. Yes, but I'd prefer, for obvious reasons, fortified, I hope, by the Lord Chief Justice in Fanning, to simply look at the formulation expressed there in Durante, to which we're enjoined to return time and time again. And to the extent that submissions stray off that path, then I will accept criticism for that. My intention is to stay on it.
I thought the test was that two verdicts can't stand together, and the consequences of that is that no reasonable jury who had applied their mind properly to the facts in the case could have arrived at that conclusion. So the test is and remains the two verdicts cannot stand together.
That's, my Lord, is two sides of the same coin in essence, because if one says, well, what does two verdicts cannot stand together mean? What it means is the two verdicts that no reasonable jury could have arrived at had they applied their mind properly to the facts of the case. That's probably dancing on a pinhead, but I don't see those as being different expressions of a test, but two ways of saying the same thing.
When you speak of the facts of the case, what are you meaning by that?
So the factual matrix as it was left before the jury, plainly, the jury can find such facts proved as they see fit, save that there is a residual power of the court to say, well, yes, the jury has primacy, can find what facts it sees fit, but there's this residual safeguard for the defendant that if a jury appears to have returned verdicts that simply cannot stand together, that can't have been arrived at by proper consideration of the facts as left to the jury, then the court can interfere, and it's a rare power, but it remains capable of being used. And if one looks at Durante, and this is why the context is not to compare facts of different cases, but to see in what context the court, approving the formulation, thought it was appropriate to apply it. There you have a jury, as in any case. They had evidence. They could find whatever facts they wanted, but they couldn't reasonably, the court found, have reached the verdicts that they did on the evidence before them, because the issue on each count was the same, and they reached different verdicts on those counts. The reason why that matters to the present appeal is that I'll come on now to deal with the sort of 5 key features of the case of the appellant, but one of those is that the issue on the counts on which he was convicted and acquitted was identical. I'll come on. That's not the first feature I want to take the board to, so I won't take that out of turn. So, but that's the shape of the law, and it's taken a long time effectively to get back to where we were in 1972, and I apologise for that to some extent, but it's because formulations such as legitimate chain of reasoning and so on had become current usage, and there's an argument of principle that says that's actually a greater trespass on the province of the jury than simply saying, look, we don't know why you may have reached these verdicts, but they just can't stand together. Seeking to place the court's, or the board in this case, own thoughts in the minds of the jury by postulating change of reasoning, that is a trespass in my submission on the constitutional primacy of the jury to find facts. So can I turn now, following that survey of the law, to 5 key features of the case at trial that are relevant to the verdicts and relevant to this appeal. So I seem to be causing feedback, and try and move forwards and backwards and see if that makes a difference. But we'll find out when I land. So in our written case, which you'll find in the electronic bundle from page 1408 onwards, or it's at tab 4 in the bundle, we make some submissions from page 1410 on certain aspects of the case, including the way in which it was put. And so the first feature of the case that I draw to the court's attention is that the prosecution case was a joint enterprise. The whole armed robbery, start to finish, 2 men form a plan, go into the bank with guns, make off after various encounters within the bank, and divvy up the loot. That was the prosecution case at trial. We don't have the opening or closing speeches, but it's clear from the form of the indictment. It's clear, I'll give the board the reference, we don't need to turn it up, but it's at page 799 in the electronic bundle, clear from the way in which the prosecution responded to submissions made on behalf of the co-defendant, Hansel Roll, at the close of the prosecution case. I have that at paragraph 11 in our written case. At paragraph 12 in the written case, you have various matters put to the appellant in cross-examination, including, from Roman 3, that Roll had come to him with a plan to rob the bank and that the appellant had agreed to rob the bank with him, that the 2 of them had travelled with the express specific purpose to rob the bank, that the two of them went into the bank, terrorised the women in there, and after you had all gotten the money, you and Hanson and Roll went back to the sea, and that the two of them had robbed the bank together sometime after 10 a.m. So clearly put case of joint enterprise in cross-examination of the appellant, and the summing up, and you have the reference there at paragraph 13 of our written case, to the prosecution case being one of joint enterprise, joint responsibility. I'll come on to the legal directions in due course, but just to note, this was the dynamic. These are the facts of the case, in the sense in which that term must be meant in the Durante formulation. It's the facts which were before the jury, as opposed to the facts which the jury found, as to which we cannot know. So that's the first feature. The prosecution case was this was a joint enterprise. The second is this. The issue raised by the appellant was identical across each of the 6 counts. It was alibi, what he said. So I wasn't there. Complete denial of participation and indeed attendance at the bank. And you have the appellant's evidence at pages 812 to 813 of the electronic bundle as to where he was. It's worth turning that up just.
Sorry, can you give me that reference?
I'm sorry, it's page 812 of the electronic bundle is where the appellant's evidence starts. Top of the page, he gives his name, where he's from, and so on. And then is asked if he knows a man by the name of Garth Thompson. At line 8, he says he does. He lives in Rolltown, Exuma. A fishing tour company. And then Mr. Watson at trial asked, can you recall the 30th of May 2012? That's the day prior to the bank robbery. He says yes. And he says he'd asked Mr. Thompson, Garth Thompson, if he could help him with some gas to go fishing. And on return, he said he didn't have no money on him at the time, but call him Friday, hopefully he will. And he asked, this is Garth Thompson, asked if he could work on the boat because he had trouble with a motor. He has more than one boat. So the appellant saying the day before the bank robbery, in which he denied participation, he'd spoken to Garth Thompson, who among other things said, can you do a bit of work on my boat? Over the page at 813, Mr. Watson, the appellant, says he went to his boat the following day. Do you know the date? This was around the 31st, I guess. Well, it would have been plainly the day after the 30th, and that's the day of the bank robbery. I went to his boat. He explains what the problem was, to do with the engine being covered in oil. Couldn't work on it. Ultimately, he solved the oil leak problem. Couldn't solve the other problem because the sun came up very hot, like midday. So the bank robbery was about 10 a.m. On that day. And so he estimated he'd been at Garth Thompson's boat for about 3 to 4 hours and left between 12:30, 1 o'clock, like mid-sun. So that's the alibi as presented at trial by the appellant. Garth Thompson gave evidence. As it happens, he was a prosecution witness. His evidence appears from page 770 in the electronic bundle. And at page 770 there, towards the bottom of the page, after being sworn, he's asked if he recalls Wednesday the 30th of May, sometime around 3:45 p.m. over the page. He says yes. About line 22 picks up, I saw my friend Deon Watson approach my car. He's described, and Mr. Thompson explains how he knows him. Over the page, Mr. Watson's then identified as the man who Garth Thompson knows as Mr. Watson in court. No dispute, he's talking about the same person. Then over on page 773, line 8, the witness is taken back to the 30th of May, asked what, if anything, happened at about 3:45 p.m. He says he, meaning Mr. Watson, approached my car, asked me for fuel, wanted to go diving the following morning, wanted to go out fishing the following morning. He then clarifies at line 15, and he asked for some gas. Mr. Thompson goes on to say he didn't have any money for gas, this is line 21, but if he went on Friday, he could get some fuel that he wants. So that's chiming with what the appellant has said in evidence. And then at lines 25 to 27, Mr. Thompson says, for that day right here, that was it, before I told him he could go and actually fix my boat if he wanted to. And he's asked about the particular reason why he wanted the boat fixed. Then over the page, page 774, he's then asked about Friday the 1st of June, so skipping forward 2 days, conversation on the 30th in the afternoon, and then Friday the 1st of June. And at that point, there's an attempted conversation with Mr. Watson, but he doesn't get through. Over onto page 775, Mr. Thompson's asked, did Mr. Watson do any work for you between the 30th of May and the 1st of June? And he says, I've got no idea. The boat was running the same way as I left it, but I've got no idea whether he'd done any work on the boat. And then the examination-in-chief rests cross-examination by Mr. Bootle from line 17, who represented the appellant at trial and in the Court of Appeal. He's asked, you didn't go out to your boat on the 31st? No, sir, and you couldn't say whether Mr. Watson worked on it or not. Over the page, confirms he doesn't know. He can't say Mr. Watson went to the boat, and he can't say he didn't. So that's the evidence on the particular alibi raised by the appellant at trial. On one view, Mr. Thompson, a somewhat neutral witness, on another, he's called by the prosecution, substantially supports the account given by Mr. Watson on the interaction between them and doesn't assist the prosecution case ultimately on the question of alibi, doesn't disprove the alibi. And so not an alibi that was inherently incredible or bound to be disbelieved on its face by a jury. So that's the second key feature of the case. The issue at the trial on all 6 counts was alibi, single issue raised by the defendant at trial. The third key feature of the case is that on the other side of the balance, the only evidence of the appellant's presence at the bank came from his caution statement. So Mr. Watson attended at the police station, and on the 5th of June, he signed a caution statement. You have that at page 639 in the electronic bundle.
639?
639.
Okay.
Yes. And we'll look at that in detail in a moment, but the third feature that I pray in aid is that this was the only evidence of the appellant's presence at the bank at all. There was no identification evidence. Compare that with the case against co-defendant Ball, in which there were 3 witnesses who spoke to him, being one of the men involved in the getaway, at least. There was no fingerprint or DNA evidence. The guns were never recovered, and nor from the appellant was any cash ever recovered. Again, compare the case of Rawle. It appears that some of the bait money handed over by the tellers at the bank was recovered because it had been used to pay his lawyer. So the only evidence of presence at the bank came from the caution statement, third point. And that caution statement, if we look at it now in some detail, at page 639 in the bundle, included admissions, which would have been full admissions of guilt on the face of it to counts 1 and 2 on the indictment, to involvement in a joint enterprise bank robbery together with Hansel. So the statement itself starts at line 26. Starts with the appellant being approached by Hansel Roll for a mission. And then from line 10, there's further interaction with Mr. Roll. He heard stories about him being a thief. Caution statement says, so I put my shirt over my head just in case. The two of them then separate, but at line 21, Mr. Roll, according to the caution statement, picks up Mr. Watson from the dock. There was a big black bag on the floor of the boat. Raised up the boat seat and showed the appellant 2 shotguns. And then the caution statement says this: he told me we have to wait until 9:30 a.m. This is when I feel that Hansel was going to the bank. I was nervous, but I just went along with him. Chamois jacket with a lot of bullets. He gave me the long shotgun with 1 bullet. They arrive at Long Island, pull up at Stella Maris. Then, over the page, there's the description there of the 2 men crossing the road, going to the bank. Hansel opened the door. I went in first. He came in behind me. He shouted something, burst a shot in the ceiling. The woman ran down the hall. I ran behind her because she ran into an office and locked the door. Kicked the door open. She said, "Don't kill me." I allow her to run back past me. She ran back where the manager was. So I followed her. Hansel then bust off another shot. I went behind the 2 women to a safe, the door before the safe, stood there, held the door open. The manager fumbling with the keys, couldn't get the safe open. Truck pulled up outside. Someone started to come out. Hansel shouted at them and said, "Let's go, number 2. Picked up the black bag, threw it there for the women to put the money in. They didn't get the safe open. 2 men ran off. And then at the foot of the page, during the getaway, according to the caution statement, Hansel then pulled out some $10 bills, some 5, and some $1 bills from his pocket. He gave me must be $1,000, and we headed for Exhumer. And so on the face of the caution statement, the submission to possession of a firearm, involvement in a joint plan with the co-defendant, entering the bank, following a woman, by inference Margot John, who ran into the office and locked the door, kicking the door open, following her together with the manager, by inference Catherine Ritchie, the evidence to the safe, which they couldn't open. And after the 2 men fled, he, the appellant, according to his caution statement, ultimately disavowed, received around £1,000 of the proceeds of the bank robbery. So clearly, on any proper application of one's mind to the facts of the case, if that caution statement is accepted as being voluntarily given, it includes admissions to involvement in a joint plan to commit an armed robbery with the co-defendant Hansel Roll, and indeed a successful plan which, on the face of the statement, the appellant had benefited. So that's the 4th feature of the evidence, the facts as they were before the jury.
Would it not be open to the jury to think that Hansel took the lead here in a big way, that he gets Mr. Watson to take him somewhere, and on the way in the boat he shows him the guns, and he told him he had to wait till 9:30, and it was at that point Mr. Watson felt that Hansel was going to commit a robbery, and he just went along with it. Now, would it not be open to a jury to say, well, that may not amount to a plan to which what Mr. Watson had agreed?
Well, my lord, that descends, maybe I would say that, but in my submission that descends into the realm of conjecture. And you have, on this case, a jury that is convicted of the appellant, on the strength only, of course, of his caution statement of being in the bank, threatening women with a firearm.
He wasn't convicted only on his caution statement. The caution statement got him into the bank, and then the evidence of the bank employees identified him
Yes.
as the person who did certain things once he accepted he was
Yes.
once it was accepted that he was there.
Yes, if he was the taller man.
Yeah.
Yes,
And
but
the critical thing in this case is whether the finding that he did certain things and been convicted for certain things, but a finding that he was not guilty of joint enterprise is inconsistent. That's the critical point, isn't it?
Yes.
And if the jury, if this is all the evidence there was of a plan, what is irrational for a jury reaching the view, well, that's not enough?
Well, on the face of it, this is the prosecution case, a trial, of course. This is a confession to involvement in a joint plan.
But they don't have to accept the prosecution case.
No, but it's difficult to see why or how a jury could properly compartmentalise the aspects of the caution statement if they accepted that it was voluntarily given and therefore accepted ultimately that it was true. Then it's not easy to see how a jury could have, or why, frankly, they should have wanted to separate out the elements of the caution statement and say, well, we're satisfied so that we're sure that this aspect is made out, but not this part here. All the more so, I'd suggest, given that on the face of the statement, the appellants actually received some of the proceeds of the bank robbery. It's not a case which obviously calls for a merciful verdict if the jury were to accept that the caution statement was freely given. Somebody admitting to involvement in an armed robbery.
Thank you.
And the fifth key feature of the case to flag up on the facts before the jury is that the contents of the caution statement were, of course, by trial, disavowed by the appellant. He maintained that it was procured through oppression, including the use of force and the placing of a bag filled with water over his head. And you have his evidence on that point from page 815 in the electronic bundle. So by 815, Mr. Watson is in the police station. He describes initially being slapped in the back of the head. He talks about being transported from place to place, and it seems, I don't think there's any dispute about this, that for various reasons Mr. Watson was taken to different police stations. And I think there was a boat ride when the police were looking for the firearms and so on. But initially slapped in the head. And then at line 22, he describes Mr. Knowles, one of the officers with him, as starting ginking him, which seems to be a reference to elbowing him in some way, keeping his foot on him so he wouldn't try to get back up. And this is all during the journey from Exuma to Long Island. But then more substantially and more relevant to the timing of the caution statement, from page 822, we're now at the 5th of June, which is the day on which the caution statement was signed. And at line 12, Mr. Watson's in a room with various officers. They start questioning me about this armed robbery case, bank robbery. I tell them I don't have no knowledge of what you're speaking about. I live in Exuma. It's a different island from Long Island. And he said, I'm not hearing that today. And he had this paper. And he was like, before the day out, you're going to sign this. And I tell him it ain't going to happen. It's a long white paper with writing on it. Mr. Watson describes being placed on the floor cuffed behind his back.
And why is all this relevant? Because, I mean, the jury were perfectly entitled to reject all this evidence, every single bit of it.
Indeed, they were, but the point is this. They could have either accepted the caution statement in its entirety or rejected it in its entirety. There doesn't seem to be any reasonable basis, and this is my submission, why they should accept parts of it, convict on the strength of that, and reject other parts.
They've got to be sure. They might be sure about some parts of it, particularly where there's evidence of bank tellers or clerks who say, the taller man did this to me. What's wrong with a jury feeling sure about having decided he was present in the bank, those parts of the evidence, but not sure about other parts of the evidence, and therefore convicting on some counts but not others? I just don't understand.
So this is where, my lady, and I'll come to this in a moment, but in my submission, it was effectively a binary question for the jury, which really, was the appellant the tall man in the bank, or was he not? That was the primary question.
Well, that's
they had
one
to answer.
question.
There are all
Then
sorts
there
of
are
questions.
other questions. Are they sure about his role and what he did, what he's alleged to have done? And I can't see why they couldn't be sure in relation to some parts of the evidence, but not in relation to others.
Well, that would have required them to have either misapplied or misunderstood the directions on joint enterprise.
Or to have felt that they could be sure about the personal responsibility for certain parts of the events, but not others. They weren't bound to find joint enterprise just because the prosecution case was put primarily on the basis of joint enterprise. It was still open to them to reach conclusions about what each defendant had done, wasn't it?
Of course, I accept that as a matter of principle, my lady, but from the caution statement we've just looked at, there is an acceptance to entering into a joint plan from which the appellant benefited financially.
That's how you put it.
Yes.
That's how you put it. You call it a joint plan. I mean, the jury might have treated it as Hansel was behind this, and this other man just went along with it. But what wasn't agreeing to a plan to rob the bank. Now, you might say, well, that's a very generous interpretation of the evidence. But on the caution statement by itself, Mr. Watson was taking a very secondary role. He was just following along what Mr. Hansel was doing.
Yeah, but he doesn't suggest in the caution statement that there's been any sort of pressure placed upon it, any coercion, anything like that. It is, I'm sure, no doubt the prosecution put it like this at trial. On the face of it is a full-throated admission to a joint enterprise bank robbery. And so my submission, obviously.
But you'll be coming to it later, no doubt, but the judge's charge to the jury made it very clear that to find joint enterprise, the jury had to be satisfied that they were in it together as part of a joint plan or agreement to commit it. And the judge emphasised joint plan or agreement as being the essence of joint enterprise.
Yes, and so it is. And on the facts before the jury, of course, this was two men running into a bank with guns, demanding money, leaving with money and splitting the money. And it's Court of Appeal of the Bahamas found it unrealistic for the jury to pass the evidence in that way. And that's my submission. It wasn't verdicts don't stand together, but equally the limiter. How many times me repeating that adds to the persuasive force of the submission. Pretty low value, but that's the proposition. That is the line of argument for the board to consider, and that's how it's put. I was taking the board through the evidence of the appellant on the circumstances by which the caution statement came to be made, And just very briefly, I was asked why I was doing that, and my answer to that is really, well, this was certainly a significant trial issue, if not the significant trial issue. Had the appellant, had the jury not been sure that the caution statement was made voluntarily, then there would have effectively been no evidence placing the appellant at the scene. He would have been entitled to be acquitted of all counts. So that's why it matters, my Lord, in response to your question on that.
Just to emphasise the point made by my lady, that is, if a caution statement is admitted in evidence and the jury are satisfied that it was made voluntarily, doesn't mean to say that they have to accept, for instance, all the exculpatory parts or all the excuses contained in it. And they're not bound to accept the whole thing from top to bottom.
Well, as a matter, I can see that one might say that a jury is not bound to accept all the exculpatory parts of the caution statement. But what we have here, my Lord, is a situation where they don't seem to be...
also not bound to accept the incriminating parts. The incriminating parts, why would he say that if it wasn't true? That's a very powerful line.
Indeed.
That you put to a jury and you say, there you are, that's an admission of guilt. Why would he say that if it wasn't true?
Yes.
But they're not bound to.
Indeed. But one they're not, yeah. But it would be unusual for...
Well, it certainly would be unusual.
Well, I say more than that, actually. It's, there would need to be a basis on which a jury could say, well, I accept these admissions, but I don't accept those admissions.
But you leave all these issues to the jury. You would leave, you say, here is the statement, it contains admissions. Why would he say that if it wasn't true? It has excuses in it. Well, you don't have to rely upon those necessarily, because he hasn't repeated them under oath, and he hasn't been cross-examined on them. That's the usual standard direction.
Yes. Yeah. Yes, but statements against interest, I don't think we disagree on this, sort of powerful evidence of guilt.
Powerful evidence.
Yes.
But has to be accepted by the jury.
Indeed.
Ultimate arbiter.
Yes, of course. But subject to scrutiny where reason doesn't appear to have been applied. And that's the terrain in which we find ourselves. So the simple point about the caution statement that I was making is disavowed. The appellant said, there was a voir dire on this, that the caution statement was found to be admissible. There's no complaint of that. The clear ruling that the judge went through the evidence and so on. But still, it was a trial issue before the jury. What was this caution statement voluntary? Therefore, was it reliable? Was it true? Could they convict on the strength of it? So those are the 5 key features of this case that I draw to the board's attention. It was alleged to be a joint enterprise. The issue at trial was alibi, the issue raised by the appellant. The only evidence of presence of the bank came from his caution statement.
Just to return to that point, it would be totally inappropriate for a judge to say to a jury, the accused has admitted in his statement, you cannot move away from that admission. It's a matter for the jury to decide whether the admission is correct or not.
Yes, I completely agree, my Lord. 4th key feature, the caution statement included admissions to the count of which he was acquitted, and the contents of that statement were disavowed. So that was a significant trial issue. So moving to the issues, 4 issues identified in the statement of facts and issues. The first, of course, is were the verdicts inconsistent? And again, I know that on 3 out of 4 of these issues, the Court of Appeal of the Bahamas was with us on this, or was with the submissions I make today. So that's the starting point, really. In answer to the question, were the verdicts inconsistent, my submission, we've been through this bit already, in fact, is the answer is plainly yes. The jury could only have convicted the appellant on any count on the indictment if they were sure that the caution statement was made voluntarily, a binary question with as I submit, no obvious basis for picking and choosing between the parts of the statement, certainly insofar as it contains admissions against interest. And so, to find the appellant guilty in relation to some of the conduct which he had admitted in the caution statement, but not guilty in relation to other conduct to which he had also made admissions, is clearly submitted inconsistent. And in that sense, the present case shares the first two of the key features of Durant that I drew to the board's attention. Number one, the appellant had previously admitted conduct of which he was ultimately acquitted. And number two, the different verdicts related to counts on which the issue was identical. So I say those factors are relevant here. The Court of Appeal of the Bahamas, who heard the appeal 6 years ago today, I think as it happens, identified what they described as the spectre of an inconsistent verdict, not least because, as they saw it, the appellant had, in his caution statement, admitted his role in the robbery. I'll take you to that, if I may. So in the electronic, it's in the key documents, but in the electronic bundle at page 1285, we have the discussion and conclusions of the Court of Appeal. At paragraph 47, at the end of that paragraph, however, to convict the appellant of it, inter alia causing damage but not armed robbery, raises the spectre of an inconsistent verdict. At 49, in his statement, which was tendered into evidence and heard by the jury, the appellant admitted his role in, among other things, the robbery of the bank. And the way that the Court of Appeal characterises the division of the verdicts, we also see at paragraph 37, at page 1280 in the electronic bundle. And given the judgment of the court, Mr. Justice Isaacs says at 37, the jury could not reasonably find the appellant was present in the bank at the material time, committing the offences for which he was convicted, but not find that he participated in the armed robbery. Yet that is what they did. He explains that it's explicable. They dutifully followed the judge's directions to consider each count separately. And goes on to note that the shorter, darker of the two men, said to have been Roll, was the one who took the bank's money physically in his possession at the time, albeit, of course, the appellant accepts receiving some of it in his caution statement. And the court said that the jury may, therefore, have concluded that the appellant had not committed those offences, albeit an unrealistic conclusion given the appellant's statement to the police. And there's that word, unrealistic, which chimes with what was identified by the court in Durante.
Yes, in the next paragraph, the court criticises the judge as to the direction and suggests that the direction set out there should have been given. Do you have any submission on that?
So my primary submission, and it's the third issue before the board, whether there was a misdirection. My primary submission is that the outcome of that issue doesn't determine the outcome of this appeal. The conclusion of that issue doesn't determine the outcome of this appeal. And but that said, and I'll explain why, in fact, first. The misdirection, if that is what it is, given the jury the indication that separate verdicts across all counts would be appropriate. It may have allowed the jury to fall into error if that is what they did, but it didn't require them to do so. So even with a separate verdicts direction, the jury could and should, we would submit, have returned proper verdicts on the evidence. They could certainly have returned consistent verdicts across all counts. So that's why the
They had
misdirection...
proper direction on joint enterprise, didn't they?
They did, yes.
So they could have followed that direction and found on the evidence.
Indeed.
If you accept they had a proper direction on joint enterprise, wasn't it for the jury to decide whether or not there was sufficient evidence of a plan to make the behaviour of the parties the subject of the doctrine of joint enterprise? It wasn't for the court, was it, to tell them that on the facts joint enterprise was made out?
No, that's certainly correct, but...
Which would suggest that paragraph 38 would have been of the Court of Appeal would have been a misdirection.
Maybe the answer is a sort of middle ground steer that one might expect members of the jury, given that the issue in the appellant's case is alibi. Consistent verdicts across the counts will follow. Either he was in the bank or he wasn't. If he wasn't, then he's certainly not guilty of any of the counts. If he was, you may well think on the evidence given.
But there could have been, and I'm not saying there was, but there could have been a bank teller who concocted a much more serious account of what one of the defendants did, thinking that they would get some compensation for whatever reason, and the jury could have concluded in relation to that particular evidence that they weren't sure that the defendants did what was being alleged. I just don't understand this suggestion that merely because alibi was the defence, that he wasn't there, that the jury would have to find the same verdict in relation to each of the counts.
Well,
the evidence was different.
Well, my lady, one of the consequences of alibi being the issue in both cases was that there wasn't a counterfactual to put to any of the witnesses as to exactly how the armed robbery had transpired. And so on the facts as they were before the jury, the evidence of the bank tellers was bound, if one took a reasonable approach to the evidence, to be accepted. So on the facts of this case, I understand the point conceptually, on the facts of this case, that doesn't...
No jury is bound to accept any evidence whatsoever, and it can reject it.
Well, of course it can, but in a case where there is no challenge to the account given by a particular witness, one simply says, well, I don't know what happened in the bank, I wasn't there, then it is unlikely, I would submit, to be a reasonable course to take to fail to accept the evidence given by the bank teller, unless there's obviously internal inconsistency, contradiction between witnesses, and the like. But that's not really in my submission the terrain we're in here. We had a series of bank witnesses and their evidence summarised in, I hope, fairly in my written case, and they, broadly speaking, give one account about what happened, which in my submission was bound to be accepted as to whether a particular offence occurred at all.
Do you accept that the direction envisaged at paragraph 38 would be a misdirection?
I think the way I would put it is it goes a little far in the opposite direction, my lord. And what one often sees in the criminal courts is a direction often sought on behalf of the defence to save any risk of sort of splitting of verdicts, is a steer from the judge along the lines of, well, you may think as a matter of common sense, either this man was the person who was in this place at this time, or he was not, and if he was not, may not have been, and the proper verdict would be not guilty on all counts. And so something in that of that order, I would submit, would have been appropriate in a case like this, particularly in relation to the appellant, and given the shape of the evidence against him. It was rather an all or nothing case, and certainly has run a trial.
So the Court of Appeal found the jury decision was explicable, so rationally explainable.
I'm sorry, my lord, I missed the first part.
They found it was explicable, the decision.
The court?
Yes.
They say explicable, meaning that it is, as I read what they're saying in paragraph 37 is, it is consistent with the direction to consider each count separately. I don't read the court there as being saying the jury is explicable on the evidence, because the paragraph concludes that this is an unrealistic conclusion, and at the start of the paragraph, the jury could not, in my view, as Justice Isaac says, the jury could not reasonably find this. They say it's explicable. They don't say it's reasonable. So it slightly begs the question what they mean by explicable there. And the conclusion
is that it would have been, he says in the final sentence, an unrealistic conclusion, given the appellant's statement to the police.
Yes.
But the jury may not have accepted the statement to the police. He complained of police brutality, didn't he?
Yes, but if they didn't accept the statement made to the police, then he couldn't have been convicted of anything, my lord, and that's exactly what lies at the heart of this. It was a binary question. On the face of the statement, there's a full confession, in my submission, to all the required elements.
To accept it in whole or in part, or to reject it in whole or in part.
But that would, my lord, on the facts as before them, would have been an arbitrary decision. There's no basis in a case where an appellant says, I wasn't there and I didn't say this voluntarily.
You're approaching this whole thing as if it's an exercise in logic. And the Mackenzie case makes it clear that's a false premise.
My lord, for a jury to draw a line between parts of a statement, on the premise that it contains full admissions, which I know is perhaps contentious, but on the premise that it contains full admissions, there must be a reasonable basis in my submission for a jury to draw that line for their verdicts to be sustainable.
I mean, for it to be a full confession, it would have had to say something along the lines of, I reached an agreement or a plan to commit with Hansel a robbery in which we shared fully in the proceeds. And those were the features that you highlighted. The statement doesn't go anywhere near saying that. He only discovered when he was partway through the journey that Hansel Rolly had guns, and he only discovered when he got to the other side that they were going into a bank. On his statement.
On his statement, yes. but he also...
So you keep saying it was a full confession, and therefore you can't draw a line between one part of the statement and another. But it's nothing close to a full confession, is it?
Well, my lady, certainly I would have thought it would be the prosecution case that it was. And a plan can be formed on a nod and a wink and so on. It doesn't need to be written down, etc.
Well, I'm not saying the jury couldn't have found that it was, but equally... it was perfectly open to them not to find that there was a full agreement with full knowledge and a joint enterprise.
Well, and my submission, my response to that is to go back to what the Court of Appeal said, and that's an unrealistic, and I would say not a reasonable conclusion on the facts, if that is what...
well, I mean, clearly, if you have the caution and the behaviour of Mr. Watson in the bank, a reasonable jury might be able to infer that there was a joint plan and he'd gone along and he had partaken in it. But is it completely irrational for a jury to say, well, on his caution statement, he is speaking of Mr. Rolly really driving the agenda, and he wasn't part of a plan to do this. He only discovered at the last minute that he was going into a bank. Now, you might think that's very generous, and a lawyer might well think it's very generous to Mr. Watson, but would that not be open to a jury?
Well, Well, I suppose, my Lord, to answer that question, the best way of doing it with reference to the facts of this case is to look at the direction on joint enterprise that was actually given.
Yes.
And see whether it works.
It's 983.
983.
983.
So it runs for a couple of pages from 983 onwards, and so they're perfectly proper directions on joint enterprise. At line 11, the judge makes the point: the evidence may be different for each defendant. Your verdict may also be different for each defendant. And of course, particularly in a case where alibi is being run by both defendants, that's clearly the only appropriate direction as between defendants. Goes on to say this, notwithstanding they've been charged as being concerned together. That's called joint responsibility or joint enterprise, as we would tend to describe it. And at line 19 onwards, it's explained where an offence is committed jointly by two or more persons, each of them plays a different part. But if they're in it together as part of a joint plan or agreement to commit it, they are each guilty of the offence. Or you can convict anyone for one of these offences. You must be sure that each defendant committed the offence either himself or that he did an act or acts as part of a joint plan with the other to commit it. Simply put, you must be sure it was in it together. You must be sure they were in it together. Plan or agreement doesn't have to have any formality to it. Agreement may occur on the spur of a moment. A nod or a knowing look. It can be inferred from the behaviour of the parties. And again, put simply, the question for you is, were they in it together? And then there's a degree of...
And I think you accept that as being a perfectly reasonable direction on joint enterprise.
Perfectly reasonable. The question is, were they in it together? And on the facts of the caution statement, I say, on its face, you have clear admissions to them being in it together, to the point that after the armed robbery was completed, the proceeds were divided between the two of them. And what better evidence, my prosecution had for a moment, could there be that this was a joint plan than that the benefit was split between the two individuals said to have been...
So effectively you're saying that the only reasonable conclusion that could be reached on the basis of that caution statement is that this was a joint enterprise. That's the effect of your submission, I think. Because if it is possible for a reasonable jury to reach a conclusion that it wasn't a joint enterprise, but that each was responsible for his particular conduct, then your argument falls apart.
Then I fail. Yes, I think
no
submission...
reasonable jury could but have reached the conclusion this was a joint enterprise.
Indeed, no reasonable jury, applying their mind properly to the facts in the case, could have applied at the conclusion. And so my submission is that the jury has failed in this case properly to apply the legal directions to the facts. And once one gets into, I'm not going to, once one gets into speculating why they might have done that, well, is it because they weren't overly satisfied with the evidence about the voluntariness of the caution statement, so decided to split the difference, and so on? That is where we must not go. That's the realm of conjecture. But the target I have to hit is the verdicts were unreasonable, because no reasonable jury who concluded, who followed the directions of law and concluded that the caution statement was voluntarily made, would have returned the verdicts that they did. So that's ultimately my submission. That's effectively what the Court of Appeal found.
Well, did they?
Yes, they... so paragraph 37, is that those opening words?
Then then you are in fact removing a joint enterprise from the jury. If the judge had asked for a route to verdict, your submission is that the charge from the judge should have been that if they accepted the statement, then the only conclusion which they could reasonably come to is that there was a joint enterprise.
The judge, of course, I accept the judge couldn't have directed that. It's a matter for the jury, but that doesn't mean that one can't subsequently analyse what the jury did. And again, in Durante, it was left to the jury.
Why leave an issue to the jury that can only rationally and reasonably be answered in one way?
My Lord, that's done, of course, formally for the constitutional primacy of the jury as the finders of fact. Of course, occasionally defences are withdrawn from juries in rare situations, but where there's a reverse burden, I know we're not in that territory, but in Durante, and I go back to that case, in that case it was left to the jury that the verdict, the return, the two charges didn't necessarily stand or fall together. That's how it was left to the jury. The jury perhaps followed that direction, found different verdicts, and the Court of Appeal said, well, they can't stand together. It doesn't matter what the direction was. It's not the direction we'd have given. What matters is not why the jury fell into error, but that they fell into error. And that's my submission, and that's why I say whether it was a misdirection or not. What the board really needs to grapple with is what were the facts before the jury, the facts from which they could have reached these verdicts, and if no reasonable jury applying their mind properly to those facts could have arrived at that conclusion, then the convictions cannot stand, however they were reached. And of course, we won't know how they were. I'm conscious, and I hope it's been helpful, but I've moved out of turn quite a lot. I was going to take the issues in turn, just taking stock of where we are. We've dealt with, obviously grappled with the question of whether the verdicts were inconsistent. I think I've said all I need to on that. Grapple with the question of whether a reasonable jury could have...
yes, you've dealt with that in answer to Lady Simler's intervention.
Indeed. Dealt with the question of misdirection. We've discussed that. One matter that I haven't touched on orally is the particular situation that pertains to count 4 on the indictment. It's developed reasonably thoroughly in our written case from paragraph 40 onwards. So if I just go to that briefly and just highlight the points that we make about it, because what effectively my learned friend says, that the counter-argument is, well, the jury have either failed to follow the joint enterprise direction or found that the test wasn't met, but otherwise, if you look at the verdicts, they faithfully applied the law to the facts as they were before them, and so that's how you know that these verdicts are not the product of a jury that's departed from reason. And we suggest that that is a flawed argument when one looks at the evidence or lack of it underpinning count 4. So from paragraph 40 onwards in our written case, this was the charge of possession of a firearm with intent by means to endanger the life of Winifred Curry. So each of the firearms charges were directed towards a specific individual. They needn't have been, but that's how the indictment's drafted. One might have thought one firearms charge per defendant, not charged on a joint enterprise basis, would have been equally sufficient. But the benefit, from my point of view forensically, is that it enables us to analyse what the jury's done in relation to Winifred Curry. The elements of the offence set out there in the extract from the summing up of paragraph 41. The defendant needs to be in possession of a firearm, and at the time of possession they had an intent by means thereof to endanger life. That is, to behave, an intention to behave in such a way as will, in fact, to the defendant's knowledge, endanger life, and so on. And then further down the page there, and this is still quoting from the summing up of the original reference, that's page 1008 in the electronic bundle is the underlying. The prosecution relies on the evidence of Kathleen Ritchie, Nicola Ayerna, and Ainan Knowles, and then further on, the weapons were held on and pressed to the backs of employees Margot John and Kathleen Ritchie. No reference to Winifred Curry. At paragraph 17 to 25 of our written case, the evidence of the bank witnesses is summarised, and paragraph 21, page 1415 in the electronic bundle, is the brief summary of the evidence of Winifred Curry. She was in her office, she heard a gunshot, she hid under her desk, Margot John ran into the office, Miss Curry went back under her desk, remained under her desk, and so on, save for periodically holding her head up to look at the monitor. She identified damage that had been caused to her office door from either kicking or a shot, so she didn't see a gun. She didn't see either of the two masked robbers in the bank, had no interaction, as she described it, with either. Margot John, in paragraph 24 in our written case, it's summarised, I don't think there's any dispute, it's a fair summary, says she saw the masked men enter the bank, she went to the office to let Miss Curry know, gunshot went off, Miss Curry was found under her desk, she got up and told Miss John to quickly close the door, and then the taller man, and this is of course said to be the appellant, shot at the office door, busted open, Miss John headed out, collected Miss Ritchie, and they departed the area of the office, and so on. And so, on the evidence before the jury, there was no basis to conclude that the taller man, whoever it was, had been aware of the presence of Miss Curry inside the office at all. And so, it follows, my submission, I would have potentially made a submission at half-time or relied upon it as a self-count to try and knock out at the end of the trial. The verdict on count 4 was unsustainable on the evidence before the jury, and that undermines any contention that what the jury has done in this case is taken, is applied their mind properly to the facts of the case. So
was this a point taken in the Court of Appeal?
No.
Was the point taken at the trial?
No, not at half-time. We don't have the closing speeches, but it wasn't taken at half-time. Mr. Roll made a submission on all counts. Mr. Watson did not.
The point is that if the appellant didn't know Miss Curry was in the office, he couldn't have intended to endanger her life. And that's the point you're making.
That's the point, yes. And there was no better evidence against him than there was against Roll, who was acquitted on that count. So that's the point being made there. And so one can't say, well, look at what the jury actually did. The only thing we can be sure of is the verdicts on which they returned guilty, the counts on which they returned guilty verdicts. And we say, well, there's a problem there as well.
How about the footnote 7 on page 1432?
Thank you.
The difficulty we face is that this issue wasn't actually addressed at all in any of the lower courts. Footnote 7.
Yes,
right,
yes.
An answer to your case.
Yes. I suggest that footnote 7 says it's no answer to complain of the lack of any direct evidence of knowledge, because offices are places where people frequent. Well, that would have been equally valid in relation to Mr. Roll, who also had a firearm in the bank but wasn't convicted in relation to this count. Shooting about the bank near others in any event.
Well, I mean, there's no suggestion that Mr. Roll fired a gun at the door of Miss Curry's office, is there?
My Lord, no, I take that point.
Yeah. The fact is that Mr. Watson fired a gun at a door and, according to Margot John, smashed it up.
Yes.
Is that not sufficient to meet count 4? He may not have known who was on the other side of the door, but does that matter?
My Lord, I say it does for this reason. If one goes to to page 1197 of the electronic bundle, what you have there, perhaps if we start. Yes, 197. So this was an abortive hearing before the Court of Appeal of the Bahamas in September 2019, and they reconvened a month later. It's the discussion here that's of relevance. Justice Evans says, if you recall the specific charges, Mr. Bootle, Mr. Watson's counsel, the possession of firearm with intent to endanger life was centred towards a particular individual. It was not everybody, as I recall it. Not to endanger the life of everybody in the bank. There was a specific aspect to it. And that's the point that we make. There needs to be an intention to endanger the life of a specific individual on the face of the summing up to the jury.
In that office.
Indeed.
Not necessarily with knowledge that that person's name was Ms. Curry.
Indeed. Certainly no need to know the name.
Yes.
But to know that Miss Curry was there, then yes. Because otherwise, the fact that Miss Curry was in the office would be irrelevant. One can't... It could be an empty...
Door.
Yeah, indeed, but the count could have been made good if it was an empty office on that analysis, my lady. If the count is framed with reference to a particular individual, in my submission, on the face of it, and on the face of the direction... on the face of the way that the indictment was raised, that there needed to be an intent to endanger the life of a particular person, although plainly not to know their name. So that's the submission in relation to count 4, and I suggest that further weakens any contention that the jury have adopted, applied their mind properly to the facts of this case.
Did the judge give a direction in relation to count 4?
So the direction is set out in my written case at page 41. It's in the summing up, page 1008. The judge, I don't think, but I'll check this, my lord, if I may, whether there were specific directions relating to each of the counts, but because obviously a number of these were framed in the same way, I think it's just what we have here. So at page 1008 from line 3, with respect to this charge, the Crown must also prove the following: that the defendants were in possession of a firearm, and at the time of possession they had an intent by means thereof to endanger life, that is, an intention to behave in such a way as will, in fact, to the defendant's knowledge, endanger life. An intention to kill is not necessary. And then that's further clarified, but...
Yes, but I mean, there's a difference between firing into a ceiling and firing through a door, isn't there?
Yes.
Yes.
Yes, and no doubt for that reason the separate count of damage was laid against both defendants. The short point is, matter for the board, we say if he didn't know she was there, he shouldn't have been convicted of that count as it was framed.
Do you disagree with the proposition at footnote 7A? As I understood it, you said, well, that would apply to Raleigh as well, but are you disagreeing with that proposition?
Yes, I do. It's an intent to endanger life, as the indictment was drafted, of a particular individual here.
Right.
But the difficulty I find is that really, in reality, what you're doing is you're appealing against this particular count on the basis that the direction was insufficient, because the jury should have been directed that, absent knowledge that Ms. Curry was in the room, that could not possibly be intending to endanger her life. And none of that has been argued before. It doesn't advance the inconsistency case at all, because on the facts as on the directions given, it's perfectly understandable how the jury arrived at that verdict in relation to this. They arrived at it on the basis that she was in the room and he fired at the door.
Well, my lord, you have my submission on the point, which is that as the indictment was framed, that wouldn't have been sufficient, and I use that as, I would say, evidence of a jury not properly applying their mind to the facts as they were before them. But who of course, I understand the point made against me. My Lord, my Lady, that's all I wanted to say, subject to safety. But I suppose if we get, I don't think my learned friend would necessarily disagree that if these were inconsistent verdicts in the sense that no reasonable jury properly applying its mind to the facts could have reached them, then the convictions are properly to be found unsafe. If he disagrees with that proposition, I'll deal with safety, but it would be in my submission a bold proposition for him to make. But that's really the area of dispute between the appellant's case and the Court of Appeal. But they found the conviction safe, effectively on the basis that the appellant had admitted all this anyway in his caution statement. The problem with that as a matter of law is that precisely the same situation pertained in Durante, the sort of lodestar for how one might approach inconsistent verdicts, in which the defendant upon arrest had said, "I'm guilty." And that, found the court, was not sufficient to render the conviction safe or at that time, satisfactory. So despite what...
You accept there is a further step?
Yes, there is. There is, but in my submission, with this factual and legal dynamic, realistically, properly, that further step that oughtn't to add anything to the exercise that the board is required to perform. And I say I make that submission fortified really by what happened, by the outcome in Durante, despite a clear confession to the count of which the individual was acquitted, that on which he was convicted, disavowed, as in the present case, at trial. And so what we say the height of the submission is that the appellant, on the face of it, has been acquitted of 2 counts to which he admitted guilt and convicted on a count on which, properly analysed, there wasn't sufficient evidence to found the conviction. And that, taken as a package, illustrates that this was not a package of verdicts, or a set of verdicts returned by a reasonable jury applying their mind properly to the facts of the case.
Right, but if the jury accepted on the basis of the statement he was at the bank, then simply on the evidence of the bank employees, they could find the convictions safe, couldn't they? They don't have to rely on anything else in his cautionary statement.
No, they don't. They could have done that, but had they done that, in my submission, they would also have, applying their minds properly to the fact of the case, convicted on counts 1 and 2. And it's the fact of the inconsistency, as in Durante, if they found that he was capable of forming the intent to, I can't remember which way around it is, but perform one of the acts, then they would have found, properly applying their mind, that he was capable of forming the intent to the other. And it's the fact that they didn't return consistent verdicts is what tells one, in the case law on Durante, that the verdicts cannot stand, meaning that no reasonable jury properly applying their minds to the facts of the case could have arrived at that conclusion. And of course, it only arises in cases where there's a conviction and an acquittal, at least. So there's always going to be that dynamic at some remove to this type of argument. My Lord, my Lady, those are my submissions, unless there's anything else I can insist on at this stage.
Well, thank you very much, Mr. Lewis. We'll adjourn for a few minutes to decide what we make of the special judgment. Well, Mr. Pennington Benton, I'm sorry to say that we won't require to hear from you. We will simply tender our advice to His Majesty.